The original one is now in session.
Please be seated. This is CV16 0502 Kisner versus Broome. These proceedings are being audio and video recorded, so we ask counsel to please identify yourselves and your client before you begin your argument. Each side has 20 minutes. Appellant's counsel is responsible for watching the clock to reserve any portion of the time for rebuttal if you desire. I will let you know that we have reviewed the briefs. We've discussed this case in conference. And counsel, you may proceed. You're actually sitting on the wrong tables, but that's either here nor there. I wondered why you wrinkled your eyes when I said appellant and looked at you.
Sorry about that, Your Honor. Good afternoon, Your Honors. My name is Eric Hawkins. I'm the attorney for the appellant and defendants. James Broome and Benedict Anthony are here in the courtroom with me this afternoon. I'll jump right into it. Thank you, Your Honor. This is a case between two longtime shareholders, partners in a ambulance company in Benson, Arizona, Mr. Montre and Mr. Kisner, that was against my clients, Mr. Anthony and Mr. Broome, as well as multiple other defendants. There were 19 counts originally in this case, and the trial court awarded damages on only one count, count 12, which was a breach of fiduciary duty claim. I just want to start real quickly with the standard of evidence on a breach of fiduciary duty. Even the trial court agreed was a clear and convincing evidence standard, which requires the court to be substantially certain that on the facts in order to find against the defendants on a breach of fiduciary duty claim. The issue of the 19 counts is important because my client prevailed on a number of those counts, and one of the major errors that the trial court made was using, for example, my client prevailed on claims regarding reducing the number of directors. My client prevailed on claims regarding appointing certain people as directors. They prevailed on those claims. And yet, even though the judge ruled for us in our favor and found those actions to be strictly legal, is what she says in the ruling, she still used those instances of reduction of directors to find against my clients under count 12 breach of fiduciary duty. It's our position that that was arbitrary and capricious to find that legal actions that she found were consistent with the shareholder documents, consistent with the bylaws, consistent with the rules and laws of the state, that she's then moved on and used that against us in her finding on count 12.
But counsel,
yes, Your Honor.
Certainly acts that are strictly legal, reducing the number of directors, can nonetheless be part of an action freezing somebody else out, can they not?
They could, Your Honor, but if the actions are found to be consistent with all, two things. First off, if they're consistent with all of the corporate documents, while it may be possible to look at that and frame whatever happened based on those actions, I would note that, for example, on the reduction of directors, the court found that my clients obtained legal advice and were proper in receiving legal advice, and that they were reasonable to follow that legal advice in that action. The same standard regarding legal advice applies to breach of fiduciary duty, and yet the court didn't go down that road in terms of fiduciary duty. She only went down that road in terms of the breach of contract claim regarding whether the bylaws were violated or not by reducing to the number of directors. So we think there's a substantial inconsistency there that she essentially allowed one defense under a breach of contract claim. The statutes under breach of fiduciary duty, you have just the same rights and defenses to rely on advice of counsel, especially when you're the officer of a corporation.
The conduct is different, and the effects are different. Right. And reliance on advice of counsel is not an absolute defense. So the fact that it worked in one count doesn't necessarily mean it needs to work in every count, does it?
It does not mean that it has to work in every count. However, in this circumstance, when you have the action is a vote that's consistent with all the corporate documents, which is something that all of the parties have agreed to, and the court finds that that is consistent with what everyone's agreed to in terms of how everyone may act, I would argue that that makes it very difficult to then get to a claim of breach of fiduciary duty when all of the parties have agreed that that's an acceptable standard.
I think characterizing the entire body of facts in this case as a simple adherence to what the parties agreed to is awfully kind.
That's only one piece of it. I agree with you, Your Honor.
There's a lot more that I think many parties would say they didn't agree to.
Okay. Well, and let me jump into a few of the other points that we would make, Your Honor, in terms of the errors that we think the trial court made. Number one, in terms of analyzing the salaries that were paid, that was the major issue in this case, or that, at least in terms of damages, that's what it came down to. The expert for the appellees in this case, the trial court decided to rely on that expert entirely. We've presented you extensive evidence and testimony that while Ms. Kitagawa, who was the expert, presented testimony that the 50th percentile, she said, she came up with numbers for the 50th percentile and said that this is the 50th percentile of pay, and the court eventually found, well, that was the appropriate level. This completely ignored the substantial evidence presented in the case, which was that Ms. Kitagawa admitted there were 7 different factors that a company would look at in determining whether pay would be allowed or reasonable to be above 50th percentile. Now, of course, some companies are above the 50th, some are below. That's how you get to a 50th percentile. But the court completely ignored the fact that Ms. Kitagawa admitted there were these multiple factors you should consider, also admitted that she didn't have any of that information. And then we presented extensive evidence as to the experience, the fact that the company had tripled in value under the management of my clients, the fact that the revenues had dramatically increased, the substantial
that tripling in value inured to the benefit of the shareholders or to your clients?
It had gone to the benefit of the shareholders. And in fact, even at the agreement of the shareholders, it had gone in 2007. All of the shareholders voted, and the value was set at $490,000.
That's when the shareholders were receiving dividends masked as salaries, right?
Well, no, Your Honor. I don't think that there was ever any evidence that there were dividends that was. Well, I believe the timing of that is that was before that. Number one, there were tax dividends, but not regular plain dividends.
I mean, as long as we're talking about advice of counsel, counsel opined that the original system of paying shareholders was imprudent and wrong, right?
That is correct. That's correct.
And that shifted then into a regime where only certain shareholders were paid.
Well, it shifted into a regime where those employees who were actually working for the company were paid. The testimony and evidence was that Mr. Kisner and Mr. Montroy did not have any employment role with the company.
So why were they getting paid before?
Well, at the mistake of the company, I guess is what I would say. And during that time, frankly, all of the shareholders were directors at those points, and they had...
So your clients ratcheted up their own compensation, decreased the compensation of others to benefit the company?
No, Your Honor. When my clients came on and became employees of the company, and I guess that leads me into one other mistake of the trial court. I think it helps to highlight that point. There was much made by the trial court about the change in Mr. Anthony's salary from 2008 to 2009 being a 150% increase. The evidence showed, and it's essentially admitted, there was nothing to dispute it, that Mr. Anthony didn't start until mid-2008. So, again, it was the judge taking apples and oranges and looking at half a year of salary versus a full year of salary. That's when Mr. Anthony came on as an employee of the company and started to receive a salary for work being performed for the company.
I understand. And as you point out, I think one can envision a situation where one comes into employment and starts receiving compensation for that employment, and that is itself strictly legal. But why is the court unable to look at the entire pattern of activities and make its own credibility determinations based on that pattern?
Well, Your Honor, I don't think that it goes so much to the issue of credibility as it goes to the issue of the evidence that even plaintiff appellee's experts said should be considered, and those 7 factors that could be considered in deciding whether pay should be above the 50th percentile. We provided extensive evidence, and I would point out even the past historical payment and salary of Mr. Kisner, and I think that's vital here, that he had received as much or more than Mr. Broome had received as CEO for a smaller company with almost the same shareholders in the same state, in the same industry.
I don't want to take away all of your time to address other issues, but I think it may be a little too narrow to talk about this case as if it were about the absolute value of a salary. This is a freeze-out case. Isn't the question whether the minority or the frozen-out shareholders were treated in accordance with the fiduciary duty that the board members, the remaining board members, owed them, not whether a salary should have been $150,000 or $140,000.
Right. And, Your Honor, what I would say is that when with a highest standard such as it is, with clear and convincing evidence, when my clients acted consistent with advice of counsel, consistent with the corporate documents, when they created increased revenue, when they tripled the value of the company that benefited all of the shareholders, when they ran a company that the evidence showed, even in the court's ruling, the indication was that the company was run well, and there were extensive evidence described as to the reasons why Mr. Kisner and Mr. Montre had been removed as directors in the case. It wasn't a freeze-out, frankly. Even the trial court found that Mr. Kisner had said, "I hope you all die." Mr. Kisner had run the other company, Arrowhead. The evidence shows and the documents show that it was a high-debt company by the time that he was terminated at that company. There was extensive evidence that was a reasonable effort. And again, that's why I think the issue of the prior rulings on the other counts matter so much, because not only do the facts go in our favor, the reasons for going above the 50th percentile are not addressed by the other side, and we present the evidence showing that that should have been considered. And then you act in every way in compliance with all of the documents that everyone has agreed to. I feel that makes it very difficult, almost impossible to reach that hefty standard of clear and convincing evidence. And I don't think that it happened in this case. And I think that the evidence shows that it was arbitrary and capricious for the court to simply ignore that evidence without other evidence to contradict it or to rely upon.
You also made a limitations argument.
I did, and I will jump to that. Thank you very much. You'll keep me on track. The statute of limitations, I think, is a very important issue in this case. Number one, the judge gave damages going back until 2009, even though even the very first claim in this case was filed in 2013, January of 2013, and that wasn't even the fiduciary duty claim. That claim didn't come until August of 2014. The court, I think, made a major error in the decision that she found that the statute of limitations was tolled. The tolling of the statute of limitations was based entirely on a document that is labeled Board of Directors Compensation and lists the directors of the company. And for 2008, for example, each and every one of the directors is receiving $13,936, whether they're the CEO, the CFO, a non-officer, whatever they may be of the company. The court found that this document, which the evidence, and it's in the briefs, but Mr. Kisner had specifically requested Board of Directors Compensation. He received a document labeled Board of Directors Compensation. All of the evidence in the record shows that this accurately showed what the directors were being paid to act as directors.
To act as directors, but Mr. Broome was director, and he was also CEO.
Yep.
So it really, in fact, wasn't all the salary that director was receiving from the corporation, was it?
It was not, but it was not framed as that way, and I think that's the key, because Mr. Kisner and Mr. Montroy, just like all of the shareholders, were receiving annual financial statements that listed officers' pay, which for those years was 1 year it's over $400,000, 1 year it's over $300,000.
But when Mr. Kisner makes a request for information, and he's given the type of information that he's given, it reminded me of a lawyer responding to discovery back before the disclosure rules. It was not a fulsome, fair presentation of the information that was requested, was it?
Well, I think it was.
If your clients had asked you for the same information, you wouldn't have crabbed your response quite so strictly.
A couple of things, Your Honor. First off, Mr. Kisner was allowed to come to the office and review documents. He admitted that. That's in the record. It's undisputed. He had the chance to look at anything that he wanted to look at. Second, when he received this Board of Directors compensation document that listed $13,000 per person, I think the question is whether or not he was actually deceived by that document. I think it's unreasonable for someone with his past experience. He'd been a director, he'd been a CEO, he'd been a fire chief, he was a chairman on a Board of Directors for a credit union. My clients provided these Board of Directors. I think it would, frankly, I think it would have been, it's hard to believe that they would have been trying to pass off that they were only getting $13,000, because they were handing him financial statements that showed that there was much more being paid than that. Plus, he admits that he had obtained documents from the Department of Health Services back in 2010, that's in the record, showing that their salaries were above that. And there's testimony from both Mr. Montroy and Mr. Kisner that they had objected to those salaries going back before that. And I think it's important to look at the legal standard. I think it's Ring versus Walker, I believe, that talks about the duties that he has in terms of diligence in looking at what salaries are being paid. I think it's frankly difficult to think that my clients, they knew how experienced he was. They knew his expertise. They provided him with these documents, and he was then allowed to come. He signed a document saying, I've received everything that I wanted to receive. There's absolutely no evidence that in those coming years then he followed up and said, I don't believe you, this isn't everything, this isn't, I wanted officers' pay too. From my client's perspective, if he asks for director's pay, you give him a document titled director's pay. There's nothing deceptive about this document, and he never follows up whatsoever. And he has all of these other documents that allow him to know know what the level of officer pay is. Even the fact that he had worked with these same folks and had made $200,000 a year as CEO. The idea that there, as the court found, that there was actually deception or there was actually some reason to toll the statute of limitations because he didn't know or could not have reasonably known. He could easily have reasonably known if he just set the two documents side by side. Frankly, I think the evidence shows that he did reasonably know what they were because his testimony.
Hold on. Assuming that we agree with you on the tolling aspect, does that bar the entire claim?
I think that it does, Your Honor, yes, because at a minimum it bars all of those years going back from when the fiduciary duty claim was made, 2 years prior to that, and that was not made until August 2014, so that substantially limits damages. But I think it also then ties into our arguments that we made regarding latches and waiver and statute of limitations. Because, Your Honor, if they allowed this to go on for years and years, when they're saying we wanted to file a lawsuit back in 2010 or we'd complained about the salary for years, and when they receive those annual financial statements every single year that show that officer pay, they know how many officers there are. They know that there's over $300,000 to $400,000 in salary. So it's, one way or the other, they're able to sort that out pretty well, and they even admitted in deposition that they were. That's in the record. I think that goes to a way.
Let me just refine Judge McMurdy's question a little bit. I think what he's getting at is, let's say that there is a statute of limitations bar. And the case was filed in 2013. Anything before 2011 is clearly out at that point.
Yes, sir.
Let's assume then that liability is established and some damages arrive in 2020. Are damages in 2020 barred because there was a statute of limitations violation in 2011?
And I think my answer was that on pure statute of limitations, the answer may be no, but when you read it in conjunction with waiver and latches, then I think the answer is yes.
Okay, thank you.
Your Honor, I've got 1 minute. I'll reserve that if I can.
All right, thank you, counsel.
Good afternoon. Rebecca O'Brien, appearing on behalf of James Kisner of the Kisner Family Trust and Michael Montroy. Mr. Kisner is in the courtroom with us today. So I'd just like to begin to refute a couple of issues that Mr. Hawkins mentioned. First of all, this was an ongoing pattern of conduct by appellants to completely deprive my clients of any benefit from this company for at least 5 years. And it was ongoing, it was intentional, and the court's rulings on the breach of fiduciary duty claims, aiding and abetting and conspiracy are adequately supported by the evidence. On appeal, the appellants have challenged in their notice of appeal a number of findings of fact in the trial court's ruling, and if you go through those findings of fact, the majority of them are supported completely by the evidence cited by the trial court, and it really comes down to some findings on credibility of Michael Montroy, Jim Kisner, Kathleen Kitagawa, appellee's expert, and the court's finding that appellant's expert James Fox was not credible. And so the heart of this case turns on the trial court's assessment of witness and expert credibility determinations, which are not to be disturbed unless there's a very clear error. And so we would submit that all of her findings are adequately supported. This trial went for 7 days. These people were on the stand multiple times. She had numerous opportunity to observe their demeanor and assess their credibility.
I do have a question, though,
Sure.
About the statute of limitations, and even accepting the judge's finding that there might have been that your clients might have been misled when they received this director's salary document that just said $13,000 for each. There was other evidence there that said that your client had other information around that time and immediately after. There was the statement that he was ready to file in 2010. There were the DHS records. There were the annual reports that showed employee salaries. Even if he was misled by that one document, wouldn't there have been a time soon thereafter when he would have been put on inquiry notice of the amount of salaries for these senior level employees?
So our position on that, Your Honor, is that the breach of fiduciary duty was the statement in February of 2009, we're suspending shareholder profit distributions because we need to save money for a rainy day. And that, in fact, did not happen. As the court noted, that practice had been to pay out profit in the form of salary, and what actually happened was everyone except my clients continued to receive those salary distributions, and they were, in fact, excessive. And despite Mr. Kisner's diligence in asking for information in March of 2010, and by the way, when he asked, the appellants owed him a fiduciary duty of full disclosure. And so if he didn't ask exactly the right question, under the circumstances, they owed him a duty to tell him the complete salaries that were being paid, which were very dramatically different than $13,000 something per year. And
I agree with that. And
okay.
let's accept the trial court's finding that he was misled by that document.
Right.
But then the question goes on, weren't there other things
Right,
available
and so
to
then
him?
he drove up to Phoenix. He's not a computer guy, went to look at the Department of Health Services report, which stated different amounts for the salaries. But the key issue there is those salary amounts were not out of the ballpark. And he was entitled to rely that those salary amounts were actually true, when in fact they weren't.
But is that really the essence of your case, that there was a salary that happened to be too high? Or is it that the cumulative total of the salaries being paid to shareholders who were also serving in other capacities was a lot higher than had been represented to him?
Well, it's both. So,
but if it's one, if he can tell from the DHS records and the discrepancies with the disclosures made to him and the annual financial statements that there's a problem, doesn't that trigger his duty to file? He doesn't have to have a full damage calculation.
sure, but what I'm saying is he couldn't tell from the DHS report that excessive salary amounts were being paid. They didn't say that James Broome was getting paid $200,000, which he was, which was clearly excessive, as the expert noted. So the DHS report in and of itself didn't put Kisner on notice.
But he knew what he was getting, right?
He
Which was
knew-
nothing.
Well, he knew he was getting nothing, and he knew but he didn't know that all the other shareholders were getting paid a lot more than they should have been.
Well, surely he wasn't comfortable with the information he was learning, right? He kept asking because he wasn't satisfied.
And he asked Broome about the discrepancy between the DHS report and that memorandum that said they were getting $13,900, and he didn't get a response. And, I think the appellants had a duty to disclose their salaries from the get-go, but when specifically asked and they failed to disclose, that's a continuing concealment that continues to toll the statute.
Well, it may be a continuing concealment. It may even be a continuing breach of fiduciary duty, but it's also something that triggered your client to go on investigating because he believed there was some breach of fiduciary duty. Now, once you're aware that there's a breach of fiduciary duty, I'm not sure that continuing concealment of certain details extends the statute indefinitely.
Well, I don't think that he knew that there was, and the heart of the case really is that the payment of the excessive salaries was a de facto dividend payment to the exclusion of appellees.
I understand. That's
Right.
the core of your case.
Right, and so absent some type of excessive payment, he wouldn't have been on notice to know, that was occurring. And I don't know what else he actually could have done. I know that appellants say, that he could have looked at the financial statements. The financial statements had a lump sum category for management. And the testimony in the record was that my clients could not determine the specific salaries from those lump sum amounts. But even
I knew that it was large.
even assuming they knew it was large, that didn't occur until March of 2011, which we would say certainly put it well within the statute with the filing on January of 2013. And the tort claims that were later pled when the defendants finally disclosed the true salary amounts, the trial court held that those claims related back to January of 2013. And so, those were timely. Alternatively, we would say it's a continuing breach of fiduciary duty, and on a continuing tort theory, the claims were timely. Alternatively, it was unjust enrichment. The trial court would have found for us on that, except that she held, she gave us the legal remedy under breach of fiduciary duty. Finally, I just want to address one thing in Walk v. Ring, because it does specifically state in the context of a fiduciary duty fraudulent concealment that the standard is actual knowledge. And so And that's paragraphs 34 and 35 of that opinion. The cases cited by Justice Feldman refer specifically to the fact that when you are in a fiduciary relationship and there's a repudiation of trust, the statute is told until actual discovery of that repudiation. And so,
Well, when did your client, in your theory, when did your client actually discover it then? What date was it?
January 2014, when the salary information was first disclosed. And I would also argue that's when the claim accrued, because the claim accrues when you have sufficient facts to have knowledge that there's a cause of action, and you have the who and the what. And the what here is the excessive salary payment.
In 2010, they received a document that showed a 49% increase in management payments. At the same time, am I incorrect about that?
I don't think that is correct.
All right. And I don't have the transcript here in front of me, but that was my understanding, is that the April 2010 financial statement revealed a nearly 50% increase in management salaries. And
but they
at
wouldn't
the
have
same
received
time,
that until 2011, at the shareholder meeting in 2011.
the transcript reference I have indicates that they received it in 2010. But in any event, if we're talking about the difference between that and 2014, when salaries go up by 50% and shareholder payments go down by 100%, isn't that inquiry notice? Isn't that enough to realize that there's a problem with the way certain shareholders are being treated?
I think it may be, but I think the record is that my clients receive the annual financial statements generally in March or April of the year following the year end.
Yes.
So they wouldn't have known. But even if they did, Mr. Kisner specifically asked Broome in March 2011 about the discrepancy and was not provided an answer. And I think that's a continuing concealment. And I think the fact that...
But what if he never received an answer? I mean, would we still not have accrual of the claim?
I think under the actual knowledge test in Walk v. Ring, you may not.
Okay.
Yeah. Let me see what else. Regarding our expert, the trial court credited the testimony of appellee's expert, Kathleen Kitagawa. She's has over 30 years of experience. She considered the relevant factors. Appellants contend that she didn't know what the appellant's jobs duties were or something of that nature. She relied on their deposition testimony regarding their job duties, whereas Mr. Fox relied on an interview with Mr. Broome and his attorney only. She also relied on salary surveys that compared appellant salaries to companies with the same type of gross revenue, whereas Mr. Fox used companies that had gross net revenue between 75 and 100 million. She used national salary surveys, which would have already given appellants the benefit of the doubt on that. And so she did use the relevant factors. She did testify that appellants' salaries were excessive, that the 50th percentile was the appropriate measurement or benchmark to use, as did appellant's expert, Mr. Fox. That's in the record at AA 59 to 60. In his deposition, he testified 50th percentile is the most appropriate percentile and the percentile used by the IRS in determining what's a reasonable salary. So I think the trial court's determination to credit Kathleen Kitagawa's testimony and not credit Mr. Fox was well within her discretion and should be affirmed. Her damages calculation was well thought out and had a reasonable basis for it. If the court has any questions on that. Let me see what else. I would just say that the other ongoing theme going through this was after there was a fallout, obviously, between Mr. Broome and Mr. Kisner. And after that, there was really a concerted effort, and it's shown in the trial court's ruling, to get Mr. Kisner completely out of management of HCI, but also to deprive him of any type of value. And part of that was refusing to update the value of the company. And that was very important because the value was what would be paid if a shareholder became disabled or died. Mr. Kisner had a heart attack on October 31st, 2010. He had triple bypass surgery, and he could not get appellants to update the value despite numerous requests. They even ultimately hired an appraiser to value the company, and the appraiser said it was worth $1.49 million. And Mr. Kisner made a motion at a shareholders meeting to set the value at that amount that was determined by their own appraiser, and they all voted no. Instead, they offered to buy him out at $9.60 a share, which is approximately half what the court ultimately determined was the value. And so by doing that, they forced him to have to hire an appraiser. We had expert testimony. We had to take the issue all the way to the courthouse steps, and ultimately we did get the value updated, but that was really because of what Mr. Kisner did, and it shows the links to which appellants were seeking to deprive him of benefits and breaching their fiduciary duty. I guess you guys have any questions? Let me look and see if there's anything else I wanted to address. I would just say that in the notice of appeal, appellants included count 15, which was the judicial dissolution count, but there wasn't anything mentioned in the brief regarding it. The court exercised her equitable power to order a court-ordered buyout of the company. That did occur in May of 2016, and I don't believe that's being challenged here. I certainly haven't heard anything about it. We would ask that the court affirm the trial court's ruling in its entirety. I guess the one thing I will address is the aspect of the court's ruling where it held there were legal actions taken that amounted to breach of fiduciary duty. It's true that some of the items she mentioned, such as appointing a new, basically expanding the board in a special board of directors meeting just 4 days before the annual shareholder meeting, effectively depriving appellees of the opportunity to be included in that process, was technically legal, but it showed the appellant's intent to deprive appellees of that opportunity. And her ruling was not entirely based on just there were a bunch of legal actions that amounted to a breach of fiduciary duty. It was also that they did pay themselves the excessive salaries, that they did refuse to update the value of the company. And this was an ongoing for 5 years. So this wasn't just, this was an extreme freeze-out situation, and the court's ruling is more than supported by the evidence her credibility assessments are entitled to great deference, so we would ask that you affirm the decision entirely.
Thank you, Ms. O'Brien.
Thank you.
Mr. Hawkins?
Thank you. Very quickly, I'll just jump in that the statute of limitations, 2 years. The items that got wrapped up into count 12 about 2010 expansions or reductions of the directors, those are all outside the 2 years time period as well, and yet they get swept in support of count 12, even though they lost on
If
the
they're
other
not
counts.
independently actionable, they can be facts in support of a timely claim, can't they?
Well, but if they are, if there's, I think it goes to the notice issue that if you're concerned about salaries, et cetera, and then you're being removed out, aren't those all triggering items as well that need to be considered? And how can you use those? One thing, just real quickly, Your Honor. Appendix 1720 and 1728, it's not 2011 that they received the 2009, it's 2010 that they get the 2009 financials, and there was $425,000 in management wages that year.
All right. Thank you, counsel. The matter will be taken under advisement. We're going to take a short recess to prepare the courtroom for our next argument. Thank you.
Okay, thank you.